Well, good morning and welcome everyone that's logged on right now. We're at the top of the hour, and so we're going to get started as we have a lot to go over today, and we want to make sure that we'll have enough time to address everyone's questions. Also, we will have a brief survey at the end of this presentation to solicit your feedback and topics that you'd like addressed at our next presentation. Colony West is very pleased to bring you today's webinar hosted by OutlookHR and featuring Hudock Employment Law Group. Before I introduce our speakers and tell you a little more about Colony West, here are a few housekeeping items. Today's webinar is being recorded, and a copy of the recording will be forwarded to everyone who registered for the event, along with a copy of the presentation. Please be on the lookout for that at either the end of the day or then the next day or so. If you have any questions throughout the session, please use the chat box. We do our best to address all questions during and at the end of the presentation. And again, whatever questions that we weren't able to get to, please address those in your survey, and we'll make sure to try to cover those in the next presentation. And now for the main event. For those of you who are new to Colony West, we are a full service advisor providing solutions to insurance, payroll, HR, and safety needs of small and mid-sized companies. We take a unique approach to every business and specifically address their individual needs and risks. We are pleased to be able to bring our clients valuable, relevant, and current information around risk management, labor, and safety compliance. As I mentioned, OutlookHR is hosting today's webinar. The team at OutlookHR has partnered with Colony West in providing customized, innovative solutions to workforce management, which includes payroll, HR, and safety. I am pleased to present Evelyn Blanco of OutlookHR. Evelyn has over 20 years experience in human resource management and is certified by SHRM, or the Society for Human Resource Managers. Our esteemed panelist from Hudock Employment Law Group is Mr. Robert Hudock. Robert has over 2 decades of experience as an attorney, with over 10 of those being dedicated specifically to representing employers in employment law matters. Now I'm going to hand it off to Evelyn of OutlookHR.
Good morning, everybody, and thank you for joining us. We appreciate your time, as we know it's very valuable. Excuse me. We will be going over several topics today, and I'm going to show you our agenda. Of course, we are going to be reviewing the new, going over the new labor laws for 2021 and some COVID updates as well. We'll be going over cybersecurity, COVID-related topics, wage and hour and other workplace topics, and finally, statutorily protected leaves that are non-COVID related. So cybersecurity, I'm sure you all know about the California Consumer Privacy Act, and this is that you must maintain all of these things secure in your business, as well as it is extremely important to it is extremely important to have processes and protocols in place to avoid any cyber breaches. And of course, there is the option to do cyber security insurance. It is very important, and it's highly, I cannot impress upon you the importance of maintaining employee data information confidential and protecting that. And it is your responsibility as an employer to keep that secure. One of the things we would suggest is that if you don't already have cybersecurity insurance, we would strongly encourage you to speak to one of our advisors. If you are not a Colony West client, then you are free to call the toll-free number for Colony West, and you'll be referred to an advisor that can help you through the process. And then when we send out the presentation, the contact information for those advisors will be available to you on that email that we'll be sending out in the next day or two. Now we're going to move on to COVID-related topics. One of the most common things I've heard, and Robert, you may want to interject if you have as well, is are employers allowed to require their employees to get vaccinated for COVID? And ultimately, the answer is yes, with the exception of any employee who can show a religious, medical, or disability-related reason as to why they will not take the vaccination. Now, a lot of this is preliminary because we don't have widespread vaccination options at this point because it's a tiered system, and most of us have not been able to access the vaccinations. But at the end of the day, it is your option to require your employees to get vaccinated, with the exceptions that I mentioned before. One of the best approaches to take with your employees in requiring the vaccination is to explain to them why it's important and to provide a business justification for it. Oftentimes, employers try to use scare tactics, and you must get it, you don't want to get everybody sick, and that sort of thing. But a better approach that we would suggest is that you talk to them and say, you want to be able to be with your family and loved ones. You want to be able to walk freely again, like life was pre-COVID. And that is a better approach in encouraging employees to accept the vaccine. At the end of the day, if you do implement a required vaccination in order to continue to work and an employee refuses, you may move forward with disciplinary action. But again, I cannot emphasize enough that it is only, you are only able to require vaccination as employer if and when the employee does not have any religious, medical, or disability reason not to accept it. Robert, did you want to add anything to that?
Not to that subject. I have a lot to say about everything else.
Okay, wonderful. Let's move on to the next topic, which is voluntary extension of the FFCRA COVID leave and associated tax credits.
Great. Good morning, everyone. Thanks for attending. I promise we're going to deliver some value for your valuable time. Let me address this. To keep within the time frame, we're going to do some picking and choosing, and we will do our best to appropriately do that according to the importance of the topic. And this will be divided into essentially two sections. We've got statutory law and we've got case law, and we're starting with the statutory law. So on the COVID specific leave, let's take a look at what the status is of the leave that everybody knows about. And that is the leave that was provided under the Families First Coronavirus Response Act, and also the California Supplemental Paid Sick Leave. So as far as the FFCRA, that did expire on December 31st of 2020. And so what that means is employers are no longer required to provide federal, and this is going to be an important point, federal COVID specific family and medical leave, or the paid sick leave that was provided under the FFCRA. Now, the thing that continues is employers can continue to provide either form of leave, the family leave and the sick leave, voluntarily. And now here's a distinction that needs to be made. The tax credits that were associated with providing that leave under the FFCRA are no longer available under the FFCRA, but a act was passed that a separate act, the Consolidated Appropriations Act, does provide those tax benefits for that type of leave until March 31st of this year. I will say, however, and this is important, to take advantage of those tax credits, all requirements that were in the FFCRA for the leave need to be met in order to qualify for those tax credits. And just some examples here of things that are important to know. If an employee, for example, used all 80 hours of the sick leave that was available under the FFCRA, an employer can voluntarily provide that, but because the amount of sick leave expired, tax credits are not available for that voluntary provision of additional sick leave. And now let's move on to the state, California.
Robert, sorry to interrupt you, Robert, but I just want to make sure that we understand this clearly. So what I hear you say is that any organization can continue to provide the sick leave and expanded FMLA under the FFCRA on a voluntary basis through the end of March of 2021, only if they so choose. But is it also important to say that if they choose to do it for one, they must do it for all through the end of March?
Sure. Yes, that's correct.
Okay. And if somebody used their allotted sick leave and or expanded FMLA in 2020, if the employer can provide an additional 80 hours if they so choose without the tax credit.
Great summary, Evelyn.
Okay, great.
All right.
All right.
So now let's go into the status of the California supplemental paid sick leave. That expired on December 31st, 2020, along with the FFCRA. There is no requirement, so there's no longer any requirement to provide leave under that act. Being California, of course, there were no tax credits available ever under the supplemental paid sick leave, and so tax credits is not an issue under that act. So the question is, so that's everything you need to know, right? Well, of course it's wrong. It's California again. And so what there is to also consider, and this doesn't apply to everyone, what there is to also consider is whether or not the municipality in which you have your business, or either the city or the county in which you have your business, has a ordinance that provides for sick leave. I'm going to talk just to give you an idea of how these, or the typical terms of these sick leave provisions. I'm going to talk about LA for a short piece. There are other cities and counties that have these municipal ordinances. The only other one in Southern California is the city of Long Beach. And the remainder of cities and counties, I'll just list them very quickly. Oakland City, Sacramento City and County, San Francisco City and County, San Jose City, and then San Mateo County only. So with respect to Los Angeles, that municipal code was just amended on February 10th, a few weeks ago. And the time scope for that coverage is until 2 calendar weeks after expiration of Los Angeles's COVID-19 local emergency period. Now, for those of you that operate in Los Angeles, here's something very important. Now, until that revision on February 10th, this sick leave applied only to large employers, which was 500 or more employees in the city or 2,000 nationally. The February amendment extends coverage to all employers in the city. With respect to the employees who are covered, the employees employed with the same, the employees who are eligible are those that were employed with the same employer for 60 days. And there are, similar to the sick leave provided under the federal and California law, there are, they must be unable to work or telework for one of 4 qualifying reasons. And they're similar to the ones that are under the federal and state provisions. As far as the county of LA, I can cover this real quickly. This was just amended on January 26th, 2021, and it's essentially the same as the city of LA provisions, except it's a gap filler in terms of other locations besides LA. And what is officially the case is it covers the unincorporated areas of Los Angeles County. Now, we're going to talk about some COVID-related laws that we know apply after December 31st, unlike the federal and California provisions for family and sick leave. First, we have, as it's indicated on your slide there, is some statutes that relate to Cal OSHA enforcement and employer reporting requirements. So as far as reporting, this is what has to be done going forward. Employers who receive notice of their employees' potential exposure to COVID in the workplace must, within 1 business day of that notice, provide to all employees who are present at the work site written notice of 1, potential exposures, 2, COVID-related benefits and protections, and 3, disinfection and safety measures that will be taken at the work site. The other aspect of reporting applies to employers who have 5 or more employees, and that is when the workplace experiences an outbreak. There are complicated provisions regarding what constitutes an outbreak, so we're not going to get into that now, but what I will say is that the notification requirement is when workplaces experience an outbreak, they need to provide local public health agencies information or report of the outbreak within 48 hours becoming aware of that outbreak. And very briefly, with respect to enforcement, the Cal OSHA going forward and until January 1st, 2023, has expanded power. They can issue orders to shut down entire work sites or specific work site areas that expose employees to an imminent hazard related to COVID. They can also issue citations for serious violations related to COVID without giving employers 15 days notice before issuance.
Robert, there's
Yes.
a question we have. What were the 3 things you mentioned? Can you repeat that, please?
Of course. The 3 instances, or excuse me, the 3 circumstances under which an employer needs to provide notice when it's a single employee who has exposure, any employee's potential exposure to COVID in the workplace are: number 1, written notice of number 1, potential exposures; number 2, COVID-related benefits and protections; and 3, disinfection and safety measures that will be taken at the work site in response to the potential exposure.
Thank you.
All right. The other, the next subject is something that came up during 2020, but it's going to continue to apply until, similar to the provisions we just talked about, January 1st, 2023, unless it gets repealed earlier. And that is the workers' compensation presumption. And if you may be already familiar with the fact that under certain circumstances, the statute says that there is a presumption that an employee's COVID-19 illness or death arose out of and or in the course of the scope of employment. And this is a rebuttable presumption. And what the statute specifically says regarding how you rebut the presumption is that an employer can demonstrate that, number 1, it has implemented measures to reduce COVID-19 transmission in the workplace, and 2, the employee's risk of infection the employee's risk of infection was actually incurred outside the workplace. And just briefly, the circumstances that I mentioned just a moment ago, under stated circumstances, there's the presumption. And the circumstances originally, back in 2020, there was the circumstance where an employee tested positive for or was diagnosed with COVID-19 within 14 days of working at an employer work site. The time scope for that expired on July 5th, 2020. So this circumstance is effectively moot. But the other two circumstances continue to apply. The second one is applicable only to certain employees in public service and healthcare. And we're talking about police, firefighters in public service, and also healthcare nurses, home healthcare facility employees, and those types of folks. And the circumstances there are when that type of employee has come in contact with COVID-19 patients, test positive for or is diagnosed with COVID-19 within 14 days of working on site for the employer. It is those circumstances under which there will be a presumption. And similar scope to what I just mentioned regarding the public service and healthcare employees, there is a presumption, and this is for employers with 5 or more employees. That situation again regarding an outbreak. Too complex to get into for our time period today, but when there is an outbreak and there's a positive test that occurred during the outbreak, then that's where there's also the workers' compensation presumption.
Robert, I just want to make sure that I understand this correctly. So in order for if I understood correctly, if somebody has a claim and it is accepted, the only way an employer can push back or argue, rebut, I guess, is that if they can prove that somehow prove that the employee did not contract COVID in the workplace, but rather outside of the workplace. Is that correct?
Yes, but there's actually two requirements, and those are the one you just mentioned, and also that the employer has implemented measures to reduce COVID-19 transmission in the workplace.
So this leads actually into one of the questions that we just received as well. So one of the things that most employers are doing and requiring are the face masks, right? None of us can go out in public without the face masks, and you have to have one. So one of the questions here is, what about when your employees and boss don't wear the mask all the time or wear it incorrectly? So my response to this would be is that is a requirement of your employment now for the time being until we're a post-COVID world. And that if an employee does not wear the mask correctly or at all, that needs to be brought to that employee's attention and corrected. And then if they continue to do so, then it becomes a disciplinary problem and a performance issue, and that has to be addressed in the same manner. Now, if it's the boss that doesn't wear it, you would have to go above and beyond the boss. If you as an employee are concerned that your boss is not wearing the mask correctly or all the time, and go above to the boss's boss, et cetera, to get this corrected. Is that a fair response in your?
I agree with that fully. And a good analogy is sexual harassment, right?
Exactly.
You just described all of the things that apply when there's sexual harassment in the workplace. When you report it, to whom you report it, what needs to be done in response to a report. So that's a good way to think about it.
Awesome. Thank you so much.
Getting back to the workers' comp presumption for one moment, and this is an important piece, that this again is applicable only to employers with 5 or more employees, which is probably most. Any employee who the employer becomes aware of having a positive test must report that to its workers' comp insurance carrier.
Which also brings up another question, and I actually had somebody that I was working with not that long ago, is that even if it's a positive as you reported to your workers' comp carrier, that doesn't necessarily mean it's going to impact. It doesn't mean it's a full-blown claim. It is informational at this point, unless it becomes a claim where it's proven the employee contracted it at work, et cetera. Is that correct?
You are exactly right. My understanding is that the rationale or the purpose behind it is to keep better track of when there's an outbreak.
Perfect. Thank you so much.
Now, let's move on to some statutes and we can go to the next slide. wage and hour and other workplace topics. And I'll just walk through these, some of which
Robert, I'm so sorry to interrupt you. We have another question. Are we, how soon are we supposed to report the workers' comp carrier? If we were not aware, do we still need to report, and can we still report? So it is my understanding that you need to report it as soon as you are aware. If you were not aware, the minute you find out, you need to report it. And yes, I would report back cases that you just recently became aware of.
Yeah, I agree. I would do it retroactively.
Absolutely.
And, tell them the dates that you were informed to the extent going all the way back through 2020, actually.
Perfect. Okay.
Sorry. Just a moment. Almost March 19, 2020 forward.
Right. Exactly.
Yeah.
All right. Sorry to have interrupted you.
No. This is, folks, we want to try to make this not just a lecture or a monologue. We want to be able to make it as interactive as one can be in this type of situation. And so do feel free to ask questions. And Evelyn, of course, interrupt me with those questions.
Good, because we have another one.
Oh, great. But we won't be able to get to all of them, but we'll do our best in the time period we have.
So basically what the person is saying is periodically, I know I've mentioned it, when it is proven the employee contracted COVID at work, I thought that there was an assumption mandated by the governor. Do you want to speak to this? I think that they're talking about when you report it to workers' comp that it's assumed you contracted it at work. And do you want to take this one, Robert?
Sure. But let's keep in mind, the presumption applies only in certain circumstances. It doesn't apply to every circumstance because, again, the one that was most broad, that was, and I'll let me kind of read that one. What applied from March 19, 2020 through July 5th, 2020 is the presumption. The presumption applied during that time frame when the employee tested positive for or was diagnosed with COVID-19 within 14 days of working on site for an employer. That expired on July 5th, 2020. So the only remaining ones are those employees that are in public service and healthcare and employers with 5 or more employees. Yes, that's going to capture a lot of employers, but those same circumstances for those employers, the workers' compensation presumption still applies. And the circumstances are if an employee tests positive for or was diagnosed with COVID-19 within 14 days of working on site. And that's during an outbreak. That's an important limitation.
Okay. Thank you, Robert.
So as far as wage and hour and other workplace topics, like I said, we'll walk through these. We'll spend hopefully only that much time is appropriate for each. And the first subject is revisions and new exceptions to our favorite Assembly Bill and Statute, AB 5, and which is codified as Labor Code 2750.3. The revisions and the amendments and additions to that is that the bill created several new exemptions, whatever you want to call them. And it also revises the existing law related for exemptions for business-to-business relationships, referral agencies, professional services, and certain performance artists, among others. We could spend more than an hour and a half on this if we got into it in detail. So I'm just going to kind of give you an idea of some of the things that were changes. There is now what's called a single engagement business-to-business exemption. That is when there is a standalone, non-recurring event in a single location or a series of events in the same location, no more than once a week. That may be an important one for some of you. Also, that I mentioned the referral agency exemption. there is added an exemption for businesses referring customers to providers in certain services. And well, actually that was existed before, but there's some additions and clarifications. And what the new assembly bill does, or the changes do, is it clarifies how a service provider, it's, I don't know if I want to spend time on that, but it clarifies how a certain service provider certifies. And so there are requirements that go along with establishing this exemption. And so one of those is you got to certify proper licensure. You got to show that the service provider is free to maintain its own clientele, and the ability of the service provider to set or negotiate its terms with clients, and some other things. Some of the added categories are those in the Professionals Exemption, and the existing ones were categories like lawyers, doctors, securities broker dealers, and commercial fishermen. I know there's tons of you out there, but the new ones, some examples, content contributor, and some of these I know are vague, and there are further definitions to them, but obviously I'm not going to cover them here. Content contributors, advisors, producers, and folks such as that for certain publications. And then also new is licensed landscape architects, and other forest, well, I won't cover that. Here's one that might apply to you or might be of value to you: real estate appraisers and home inspectors. And then also new is it adds translators and copy editors to the freelance exemption. And then I'm going to skip over that for our time purposes. It's very detailed and maybe not applicable to many of you. But here's the important point. Always recall that when we talk about workers who are exempted from AB 5, that doesn't mean that they are automatically able to be designated as independent contractors and not employees. The categories that are exempted from AB 5 must still, at a minimum, pass the multi-factor test in California for establishing independent contractor status. You might have heard of it as the Borrello test. It's named after a California Supreme Court case. But also, that's at a minimum. Certain categories also have additional requirements that are stated specifically for those categories in AB 5. And of course, if you have specific questions regarding your field, you can always and need more detail, you can always contact your HR professionals or employment attorneys.
So Robert, just to be clear, for AB 5, we're talking about the Borrello test. Where does the ABC test fall into this? The
AB 5 is the ABC test. The
Perfect.
AB 5 is a codification, meaning it was made a statute. Because remember, the ABC test was introduced in a Supreme Court case, Dynamics.
Right.
So what AB 5, Labor Code 2750.3 did, or actually, let me put it this way. AB 5 codified the ABC test into Labor Code 2750.3. That's a way to think about it.
Perfect. Thank you. We have a few more questions going back to COVID. So
let's do it.
Go ahead and address them. So one of them says we have 40 employees that are currently working from home. We only have 3 to 5 employees going into the office 2 to 3 days a week. They have their own office and there's no interactions with other employees. If one of them tested positive for COVID, do we have to report the incident? So I'm assuming that when they're talking about if one of them tests positive, they're talking about the 3 to 5 employees that are going into the office. And my answer would be yes, you still have to report it because they are going into the office.
I guess then I'm not entirely clear. What I thought we were talking about is an employee who tests positive that works from home exclusively. Is that not the case?
Well, so the way the question is written, they have a total of 40, and and most of them work from home. However, there are 3 to 5 employees that do go into the office sporadically 2 to 3 days a week. They each have their own office. There is no interaction with other employees. If one of those 3 to 5 employees tested positive for COVID, do we have to report the incident?
Then I agree with you. Then I agree with you.
Yeah. Okay. Yeah. So
let's be clear. Reporting the incident means reporting it to your workers' comp insurance carrier.
Right, reporting it to the carrier, and each carrier has, I didn't mention this earlier, but each carrier has a specific form, and they have limited information that they ask. It is not a full-blown claim necessarily. Then the next question we have is, I have a staff who was a job coach for the person with disability who works at Albertsons. Both of them, I think it says they have COVID. The staff mentioned that it was a positive case at the store, so the staff is on workers' comp now. However, as we know, we can get COVID at anywhere, and definitely he didn't get it at our job site because our building was closed at that time. My question is, does our company have the right to step back for having this specific staff on workman's comp? I'm not exactly sure what, Trem, if you could type in the question a little more in detail again, so we make sure we answer it for you. I'd appreciate it. Then the next one we have is confirming exposure. This means when an employee has tested positive, not the employee who came in contact with a person who tested positive. Oh, wow. I'm sorry. Let me reread this. Confirming exposure. This means when an employee has tested positive, not the employee who came in contact with a person who tested positive and not confirmed positive. This question was based on the earlier answer of the 3 things to do as an employer.
I would need a little clarification.
Yes. Okay, so Danette did say she was referring to the employees going to the office. So yes, Danette, going back to your question of the 3 to 5, you would still have to report it. But again, it is limited information you need to provide. Chris Wenzel, your question is a little confusing. So if you could maybe retype it, we want to address it, but we're not quite sure what you're asking there. And then, do we still need to report the positive COVID test for the employees that are working from home?
Go ahead, Evelyn, go ahead.
My answer would be no, because they're not exposed to anybody that they're working with. They are working specifically and exclusively from home. So they would not be, they would not have contracted it at work, so to speak.
Yeah, it's all about the workplace, not
right,
necessarily
workplace.
their employment.
If you're actually going to your a specific job site where you're in contact with other coworkers, that's when you would report it. Is that fair to say, Robert?
Yes.
Okay. So we have Jennifer asking that this sounds odd. It would be the same type of situation if, say, an employee gets hurt outside of work, we wouldn't report it then. So why, if the employee contracts COVID outside of workplace, would the employer be required to report it to their workers' comp? So again, Jennifer and Robert, please pipe in. There is the presumption that they may have contracted it at work, so you report it. And again, I want to emphasize, this does not necessarily mean that it is going to be a full-blown claim. It does mean, however, that because of the laws that have been passed, it is required to be reported.
Yeah, and I'll just say the distinction between the example you gave of an employee being hurt outside of work and a COVID situation is this is something that was specially enacted into law,
because
I guess, given the circumstances where there's this presumption that it happened at work.
Correct. Okay, great. Thank you, Robert.
All right. Any more?
For now.
Okay. I'm going to skip over, I guess, some of these because they are, some of them are narrowly applicable. So I'm going to skip over no rehire provisions and settlement agreements. I'm going to skip over pay data reporting because it applies only to employers with 100 or more employees. Statute limitations for labor commissioner complaints. That's a little bit of a too specific of a thing that employers don't necessarily need to know. That's for your HR people and your attorneys to figure out, or it would be your attorneys, because if you contact an attorney about that claim, the attorney is going to look at it and see if that employee met the statute of limitations for that claim. This is something that I'm going to cover, and this is successor liability for a successor company, or let me put it this way. You've got a company that sells you've got a company that's sold to another owner. And this comes up for me all the time. What liability does the new owner have for the liabilities, and let's just talk employment related liabilities of that previous owner? Let's make a distinction. Accepting liability when it's not a judgment is something that hopefully is covered in the agreement of sale. And there's going to be a provision in there that addresses that. But what this new statute does is it basically overrides any allocation in an agreement such as that when there's a judgment. And so under certain circumstances, let's be clear on that. A successor owner is liable for a judgment against the previous owner, and this is for wage and hour liability. And successorship is defined, or the circumstances under which a new owner would be liable is, and I'm going to read these, and it's going to be a little bit in legal language, but I think this is important to know. The circumstances under which the new owner would be liable for the previous owner's judgment, or a judgment against the previous owner for wage and hour claims, is when the new owner uses substantially the same facilities or substantially the same workforce to offer substantially the same services as the previous owner who has a judgment against them. Second circumstance is any business that employs a managing agent, any person who directly controlled the wages, hours, or working conditions of the affected workforce of the previous owner. And the third circumstance is a business in the same industry that has an owner, partner, officer, or director who is an immediate family member of any owner, partner, officer, or director of the previous owner. So if any of those circumstances potentially apply to you, it's probably a good idea to get some further clarification on that so you can manage and plan for any type of exposure that might lead to. Very quickly, there is a new requirement regarding what the Secretary of State, or what is reported on the Secretary of State Statement of Information. Corporations, LLCs have the Statement of Information. A lot of you are probably familiar with it. What has to be reported now on that Statement of Information is when there's a wage and hour judgment against that corporation or LLC, or also partnerships, LLPs. That applies, well, the judgment that needs to be reported would apply whether it's a judgment against the entity, or for limited liability companies, any member or manager would also be among those, a judgment against whom would need to be reported on the Statement of Information. I'm going to skip right over rest breaks for security guards because that applies only to security officers covered by a collective bargaining agreement that has certain specified provisions. Very narrow, not worth taking up our time today. Okay, so now we get into the atom bomb of all the statutes, and that is the changes to family and medical leave in California. And so just briefly, you have federal family and medical leave and California family and medical leave. The federal is the what you might have heard of as the FMLA, and the state is the California Family Rights Act, CFRA. I call it CAFRA, Evelyn calls it CIFRA, it's all the same. And here's the big deal, if you will. Prior to this change to the statutes, the provisions of these of the CAFRA family medical leave provisions only applied to employers who had 50 or more employees within 75 miles of a work site. The change now brings that number down to 5. And that sweeps up, I venture to say, most employers in California. If you're under 5, you're lucky, and you still don't have to be concerned about family and medical leave. But if you are between 5 and 49, this is a new thing for you, and it would behoove you to at least before you actually have some, it's important, it would behoove you to become at least generally familiar with how to administer family and medical leave and the different circumstances under which it's available and some of the requirements, so that when you have an employee, when and if you have an employee who requests leave, you know something about how the different things that you need to consider. I guess at a bare minimum, just know that if you have an employee who asks for leave, call your HR professional or employment attorney so that they can, provide you with this important information. You should do that even if you have a general understanding, frankly, because this whole area is a minefield. It is nearly impossible to comply with all of the requirements, and there are very specific nuances to these provisions, things such as when can you contact an employer's healthcare provider directly? When can you ask an employee for further certification of their serious health condition, and things like that. But to state generally, what the family and medical leave requirements are under CAFRA is that as to those employees and employers to whom it applies, the employees are entitled up to 12 weeks of unpaid leave, and that leave is statutorily protected, meaning that at least as a general rule, or I should say, the employers have a duty to keep that employee's job open and return that employee to work in the same or similar position, except under certain circumstances, such as one exception called undue hardship. And so I don't want to get too detailed into that because we could spend forever on that. But there is one thing that I do want to cover, and that is the expansion of the qualifying persons, or I should say, an expansion of the persons who are qualified to take family leave. That the existing one prior to this statute was the qualifying family members, because, and I should say, to take leave, there has to be involved a serious health condition of the employee, or to care for certain specified individuals who have a serious health condition. So the qualifying family members previous to this new statute were serious health conditions of a spouse, registered domestic partner, parent, or child. The new law expands that to grandparents, grandchildren, and siblings. There's also, I just talked about a child as qualifying family members, the qualifying children as it existed are the requirements for a child to be included is the child must be under 18 years of age or 18 and over and incapable of self-care because of a mental or physical disability. Under the new law, what is added is a domestic partner's child and all children with a serious health condition, regardless of age. And of course, all these new, all these expansions are going to apply to everyone who is now swept into coverage under these family and medical leave provisions.
We have several questions.
All right. I would think so.
So first one, does this apply to nonprofit businesses? Yes. There is no exclusion for nonprofits, unfortunately. So there's that. Then we got a thumbs down on this whole topic from one of our participants. And then the next
5 thumbs down.
Yeah, seriously.
Screaming.
The next question is this SB 1383 Act 12 weeks of unpaid leave in addition to the 12 weeks of FMLA that are provided by FMLA?
Negative.
I think generally the question is you would have to you would have to determine which of these leaves run concurrently or in addition to. And that's when you need to bring in an HR professional and or your labor attorney. Is that fair to say, Robert?
Yes, in terms of the specific question, no, they do not run concurrently. The way that works is generally, and almost in all cases, well, let me back up. You need to apply the law, or you need to apply the provisions within the law, federal and California, that are most favorable to the employee. 9.8 times out of 10, that's going to be, surprise, the CAFRA. And in terms of getting back to the specific question, no is the answer, and that is, does FEMLA and CAFRA run consecutively? No, concurrently.
Perfect. Okay.
But just to add in, there are like pregnancy disability leave.
Nuances that they can pile on top of. Recently, I got a question of, how long can a pregnant person, how much maternity leave can somebody actually get?
Whoa. That's, we got to be careful there, because maternity leave.
Right. Well,
that's because
baby bonding.
Let's talk about this. There's pregnancy disability leave.
Right.
That's one, but there's also the so-called baby bonding.
Right. Baby bonding.
Right. And so maternity leave is not a legally used term, but you can also, you can always use it for a certain type of leave, but I would say that's a lot more descriptive of baby bonding.
Got it. Okay. So then the next question we have is, what if the employee that left was a nurse or doctor that looked after patients? Am I not allowed to hire another medical professional to look after our seriously ill patients? And my instinctual response would be, you're allowed to have somebody step in while that person is on leave on a temporary basis, and then potentially reinstate the employee that comes back, unless, of course, you can prove an undue hardship. Would that be accurate, Robert?
Yes, and there are other exceptions besides undue hardship. For example, when there's a safety issue and things like that, because let's remember, when an employee who is on leave returns, it is best for the employer to get some type of certification with respect from the healthcare provider with respect to their return to work. And more specifically, what I mean is a certification that they're able to return to work at full duty, or a certification that they are allowed to return to work with certain restrictions. And that gets into a whole nother area of analysis. But let me make clear one thing. If I recommend that you do that for every employee for a number of reasons, but if you do that, make sure you do that for all employees, not one or some group.
Right. And generally speaking, you know, my advice that I often speak to my clients, I say, you know, what you do for one, you do for all, in order to protect yourself.
Correct.
Okay. All right. Thank you.
That's all we have for now?
That's for now. Yeah, that's all.
Okay. So the other change I'll mention with respect to this issue of family and medical leave and other job protected leaves, statutorily protected leaves, is this is just a technical piece, but what was separately the New Parent Leave Act, and that's the baby bonding, is the act has expired, but it's simply the provisions of it were moved over to the CAFRA. And so it pretty much operates the same way. It's just in a different statutory set. And the reason I mention that is because I would not want there to be any misunderstanding that, oh, the New Parent Leave Act expired, I don't need to do it anymore. That's definitely not the case. Now, the change with respect to the baby bonding, one of the changes, the change with respect to the baby bonding is, and this is kind of a narrow situation, but it's when an employer has two parents that work for that employer. Previously, such an employer only had to provide 12 weeks as to both parents together. Now, under the new law, that employer has to provide or make available 12 weeks to one parent and 12 weeks to the other parent. One thing I'll mention that doesn't have to do with the new law, but since we got some questions about leave running concurrently or what have you, the baby bonding leave is it's now under the CAFRA, so that makes it clear, but that's the same as, or the 12 weeks is the same. In other words, you know, you have 6 weeks of baby bonding. You've only got 6 weeks left for situations that involve a serious health condition. And then I'll just throw in there that there's also the paid leave, and that's 8 weeks, and that can be used in pregnancy and birth type situations, but that's not important to get into detail today.
Okay, we have another question. It says, does it mean we may use FMLA or CFRA or both?
Yeah, the answer to that is both apply. And what you do to resolve or determine which of specific provisions do you apply the provision that is more beneficial to the employee requesting leave. Let me add one thing to what I said before. Again, 9 times out of 10, the provisions in the FMLA and the provisions in the CAFRA are exactly the same. Okay, so it's not going to be, as a practical matter, you know, a line by line comparison. And so much so that let's say you have a CAFRA provision that is same as the FEMLA provision, and there's a question about interpretation of the CAFRA. If there's no interpretation, California interpretation of that provision, you can cite and use as authority interpretations under the FEMLA.
Got it. Okay. I think we've answered that question. Thank you.
Okay, so the only thing left for changes in statutorily protected leave is an addition for time off for domestic violence, sexual assault, or stalking victims. That's pretty narrow, so I'm not going to cover that any further. If anybody has any questions, please ask either during our time now or at a later time. So that brings us to case law. And so what we've done here in this slide and the next slide is introduce those subjects that were covered in California employment law cases during 2020. And so the main topics are employment. What is employment? And under that is employment versus independent contracting, pretty expected. The definition of who is an employer and who is an employee under the law, and one that's come up a lot more since the rise in PEOs and worker supply companies of different types, is joint employment. And we'll talk about that a little bit. Then the next,
Robert, I'm so sorry. We have another question. So in respect to the question about CFRA and FMLA, there, somebody said that they missed it, and they said, so was that a yes or a no? As far as when the question you just responded to on the CFRA and FMLA, do you remember?
I want to, if they want a yes or no answer, I need to hear it specifically. I'm a lawyer after all.
Yes, you are. So I believe, and I hold on, let me look at here. So the question was, I'm looking it up. 1 second, please. Sorry about that. That they may use FMLA or CFRA or both. And it depends on the
you can't answer that yes or no, but
right. That's what I thought. Okay.
But the answer is, let me put it in a different way. When you have an employee requesting leave, look at CAFRA.
Look at CAFRA first, the CFRA, the new one, right? And then,
correct.
And if that doesn't apply, then you move on to the FMLA.
I would state it a little bit differently.
Okay, please.
Look to the CAFRA, and in almost all instances, that's what you could rely on. Okay. I don't think it's feasible as a practical matter for an employer to memorize or know where there are FMLA requirements that aren't in CAFRA or are better than CAFRA. But I think as a practical matter, it's absolutely sufficient for an employer to know all of the ways to administer leave and the requirements for certain things and interpretations. Look solely at the CAFRA, because that's going to cover it for your needs.
Got it. Okay, we have another question. An employee taking leave to care for sick daughter, not COVID related, for three weeks has not been employed 12 months or meet hours requirements. So we have confirmed he does not meet federal or state requirements for us to hold position until his return. But will be allowed to take leave, of course. He's insisting to work remotely while out of state. We denied that request, as we know he will not be able to work full-time under the circumstances. Can you please confirm if in fact we are not required to hold position, or if we can change position requirements such as reducing to part-time?
If I understand the question correctly, I heard that this employee doesn't meet the hours requirement.
Correct. Not 12 months
so
or hours.
I guess the question is not, do they have to provide leave? The question relates to returning him to work.
Right.
Is that correct?
That's how I'm reading it. Yes.
But if he doesn't qualify for leave, it doesn't apply, and there's no statutory protection.
All right. So then they can, if they so choose, offer him the option to work part-time, which is what his position and or allowing him to work part-time.
I hesitate to say you can do whatever you want.
Right.
Because there's always things that are involved that change the analysis. But speaking generally, that is because this is it, because they don't meet the hours requirements, you can just ignore the FEMLA and the CAFLA. And, I guess because for this employer to provide such leave, that would only be under a policy that they have, that they're not required to do, but they choose to give, personal leave or whatever type of other leave that's not required. And so the only requirements would be the requirements, if any, that are part of that policy, because then it's a contractual situation.
Okay, thank you so much, Robert. And I believe that answered the question. We are down to about 25 minutes. So any questions we receive as of now, we're going to get through these materials. We will, if there's time left, we will answer them at the end. Otherwise, we will send you a response via email.
Let me say this about the case law. I'm going to be able to get through this pretty quickly. Okay. And you'll see why. So let me give it a shot, and then hopefully we'll have a few minutes at the end.
Perfect.
So you can just, folks, you can look at the slides to familiarize yourself with the topics that were covered in case law. And go to the next slide, please, Evelyn. And these are the additional topics that were covered in case law. So now let's go through. I think with respect to employee independent contractor, there was a case that in federal court within California that applied the federal test for determining independent contractor versus employee. It's similar to the Borrello test. But the point of that case is that it demonstrates the high standard under California law. And I could talk about the facts of this and the kind of distinctions, but that's a little too involved. But let me just say this, there were arguments that the employer made, or the contracting entity made with respect to this person being an independent contractor, and there was arguments that the doctor made as to certain subjects. The court there, because they were applying the federal test, found in favor of an independent contractor. But I think almost certainly, or let me just say this: it's possible that that same person under the same circumstances would not be an independent contractor under California law. Then there was a case of who is an employer and who is an employee. There was a case that involved an inmate that was doing work detail. The important part of that is that's a volunteer, and volunteers cannot be quote unquote employees as a matter of law. There needs to be compensation. Okay. Now, joint employment, I'm going to spend a little bit of time on this one. There are factors that one needs to look at to determine whether one of several possible people who were involved, entities that were involved, are joint employers of a single employee. This case, or the general rule is, it's going to be like independent contractor. The case say there's no magic formula, and it's going to be case and fact specific. So there's going to be a certain level of subjectivity that's weaved into this, and it's difficult as a result, it's difficult for employers to make any conclusions ahead of time as to joint employment, but at least you can do your best job. So let me just briefly, as quickly as I can, just to give you an idea of those factors that a court would analyze to see whether there's a joint employment relationship. And so this is a list of what a court would look at in terms of what the alleged joint employer did or didn't do with respect to that employee. And that's, let me be clear too. Like the independent contractor, or the Borrello test, I should say, establishing any one factor doesn't establish that the person is jointly employed. These are all things that need to be considered together. And so here are the factors. Whether the joint employer paid salary or other employment benefits and Social Security taxes, whether the joint employer has ownership of the equipment necessary to perform the job, the location where the work is performed, the obligation of the contended joint employer to train the employee, the authority of that potential joint employer to hire, transfer, promote, discipline, or discharge the employee, and then similarly, authority to establish work schedules and assignments. Moving on, the defendant's discretion to determine and when I say defendant, I'm referring to the contended joint employer. Discretion to determine the amount of compensation earned by the employee, the skill required of the work performed by the employee, and the extent to which it is done under the direction of someone that is associated with the contended joint employer. And then, like the B of the ABC test, they look at whether the work is part of the contended joint employer's regular business operations, and the skill required in the occupation, the duration of the relationship, and duration of plaintiff's employment. A lot of those are very similar to the factors of the Borrello test. But this is an evolving area, and like I say, it's case specific, and to get into the nuances and the ins and outs of that is beyond the scope of what we can cover here today. There were cases that came out with respect to joint employment. One is where there was an application of the test and the factors. And I'll just say what the conclusion was. And that is, the court in this case, it involved a nurse who worked for a hospital. And the court found that there was no joint employment based on the following facts. There was no pay, there's no payment of salary or benefits. The proposed joint employer did not own the equipment that the nurse used to perform her duties. That proposed joint employer did not have the authority to hire, transfer, demote, or discipline, or discharge. And that was enough for the court to conclude that this was a situation where that entity was not a joint employer. There was another case about vicarious liability. I'll just briefly mention that. Well, I should probably cover vicarious liability. So vicarious liability is a situation like where you have an employee who engages in conduct within the course and scope of his or her employment, and under certain circumstances, most circumstances, the employer is what's called vicariously liable for those acts of the employee because that employee engaged in the conduct within the course and scope of employment. And so this case here said that joint employers are not vicariously liable for each other's labor code violations, but they are liable, and this is common sense, they are liable for their own conduct. And that's what that case said. Here's perhaps an important one to some folks. Those of you who have any kind of commission component to your compensation plans. And I'm getting into the subject of compensation. And that is the general rule. Well, let me just very briefly cover to qualify for an exemption. The employee needs to pass both a duties test and a salary test. This case was about the salary test, and The salary test is that the employer needs to pay a salary equivalent to 2 times the state minimum wage. I'm going to come back to that. But for the salary test, the court ruled that compensation is not counted in salary for purposes of determining how much salary they were paid to determine whether they qualify for the exemption. So let me step back to what I said before for just a moment. And that is, there's a lot of misconceptions out there among even very experienced attorneys, but this is a very clear situation, and it's very important too. And that is, the wage orders, which state the salary test, state specifically that it needs to be 2 times the state minimum wage, not municipal. And that can be the difference between whether or not that person is qualified as an exempt employee, because whatever the gap is there, between the hourly wage the state minimum wage hourly and the locality minimum wage is going to be important, and it's going to allow more employees to qualify for an exemption or to meet the salary test. Very quickly going through some cases regarding meal and rest periods. This is just a case that confirmed, this is something that's pretty basic, that rest periods are hours worked for which employees must be paid at least minimum wage. Another confirmation that attorney's fees, like almost all other employment claims, are not recoverable for the pursuit of meal and rest period claims. There was one that involved a common argument that employees make in terms of, did the employer provide meal periods, authorize and permit rest periods? A lot of times employees will argue, well, no, they didn't provide them because I had so much work that, I couldn't ever take a meal period or a rest period. But a legitimate argument in response to that is, well, we made the time available to you. It was actually you that elected not to take the meal period that we made available to you. And under that circumstance, the employer has met its obligations to provide or authorize and permit meal or rest periods. So the lesson out of that is, one of the things you absolutely want to do is have a policy in your handbook or wherever else that talks about, hey, we absolutely, without exception, there's meal periods, and you have to take your meal periods of 30 minutes or more, and language like that, because then you have something, a document to refer back to, so that you can prove that you provided the meal period, but the employee, even if the employee thought, somewhat legitimately thought that their work didn't allow them to take a meal or rest period, that doesn't work for them. The only time it would work is if someone, a supervisor or manager of the employer, said, you can't take your meal break, or you know what, when you're busy, you can't take your meal break, or whatever. There has to be an active refusal or denial in order for that type of situation to lead to liability. Travel time. Here's an important one. Case came out that, so the general rule regarding travel time is any commute from home to the first work site, and that could be, a regular office, or for remote employees to wherever their first work site is, wherever it is, that's not compensable. And also at the tail end of that, from the last work site back to home, not compensable time. However, there's an exception. Commute time can be compensable if the employee is sufficiently subject to the employer's control during the commute, such that the control prevents the employee from using commute time for personal purposes or pursuits. In that case, the facts of that case, let's briefly just review those so you can have an idea of what that means. In this case, the employer provided a copier service technician with tools and parts required to service the copiers. They were required to drive a late model vehicle with certain minimum lockable cargo space. They were required to store a sufficient number of parts in their vehicles, and manager approval was required for any exception to apply. So the employee argued that is the control. They had control over me during my commute. I should be paid for my commute. Court finds says no. None of this is the appropriate consideration for the control requirement. None of it prohibited those technicians from engaging in personal endeavors during their commute, and that's the key factor. Reporting time pay. There was a case that came out that just confirmed the Tilly's case that some of you may know from last year, and that is when an employer has something called call-in shifts, and it doesn't, when a person calls in and sees whether they're going to work that day or not, if there's no work, if that person is told, well, there's no work, they are entitled to reporting time pay for that day. Vacation pay, there was a case that came out about what's a practice that is being instituted more these days, and that is unlimited vacation policies. I think that's probably still pretty narrow. So that's something we don't need to get into detail here, but we're happy to outside of the program. Rounding, that's a little bit esoteric. It's a little bit difficult to understand. And I don't know how many of you do rounding, but I suspect that it's a number that, this nuance wouldn't be all that important. But again, if you have a question regarding that, please do contact us. PAGA, very quickly, cases came out confirming what's already been the case for a while now, several years. PAGA actions can't be compelled to arbitration. So if you have an arbitration agreement with your employees and they bring a PAGA action, that piece, at least that piece of the case, can't be compelled to arbitration. If it's a PAGA only action, then nothing in that case can be compelled to arbitration. There was a case that said a union can pursue a PAGA action on behalf of its members. And there was also a case about individual employees standing to pursue a PAGA action. And the theme of the two cases were a PAGA action is a state action. And the two holdings were, first, a PAGA action is a state action, so a judgment in a PAGA action binds all the aggrieved employees on whose behalf that individual employee pursued the PAGA claim. But as you may know, an employee who suffered at least one an employee who had at least one violation, contended violation, let's say meal periods, can pursue on behalf of other aggrieved employees, not only those meal period claims, but any other wage and hour claims that apply to other aggrieved employees, but not to that person bringing the action as the representative. But what this case said is that if there's a PAGA action litigated on behalf of aggrieved employees, and this employee, well, just a moment. Right. If they settle their case, or they pursue and settle or resolve their individual claims with the employer while a PAGA action is pending, they don't lose, based on that principle that I just said, that employee doesn't lose his standing to pursue a representative action. Let's see if we can.
Robert, we have 5 minutes.
Yep. Well, let me do this. There were some cases that came out with in the harassment, discrimination, and retaliation area. What they did was there was facts that allow someone to have insight into how you analyze it, that's pretty much it. There were other cases that were very narrow, but I think we've covered the important ones.
Okay. Do you want to answer a couple more questions?
Sure.
We have one. So this one says, past employee meets exemption requirements, was full salary, was laid off, and has made it clear he intends to sue for unpaid overtime wages that he states were banked hours. There was no agreement for OT or banking hours. He never submitted a time sheet reflecting this, nor did he discuss with anybody responsible, such as HR, payroll, or supervisor. He at some point documented total hours on site in his handwritten daily records, which were only scanned and saved by lower level staff. Please advise if you think that there is a valid claim for unpaid wages under these circumstances.
The threshold issue is, did this person in fact qualify for an exemption? And recall that there's both a duties test and a salary test. It sounds like you meet the salary test, but what you have to take a more careful look at is the duties test. And so if they don't pass the duties test, then that person is going to say they were misclassified as exempt, and they're going to do all the or this particular employee may make all the wage and hour claims that flow from a misclassification, such as overtime.
Okay. So then we have another one that says confirming exposure. This means when an employee has tested positive, not the employee who came in contact with the person who tested positive and not confirmed positive. This question was based on the earlier answer of the three things to do as an employer.
I think I know what that's referring to.
Okay.
Let me, while I'm getting back to that, let me just say that as to most of these things, the key factor is positive test and diagnosis by a healthcare provider.
Mm-hmm.
But let me go back to the three things, just a moment. And are we talking about the three things for report?
The written notice. I think the three things you're required to do as an employer: the written notice
to the government agency or to the workers' comp carrier. Well, the three things. Excuse me. Do we know?
Written notice of exposure, right? And inform the employees of the COVID-related benefits.
Oh, okay. Yes.
Three, the disinfecting and creating the workspace.
That's to rebut the workers' comp presumption, as I hear it.
Okay.
And there was only two things for that, and that is the way you can rebut the workers' comp presumption is to show that the employer that it has implemented measures to reduce COVID-19 transmission in the workplace. I don't know if this is what we're talking about, but and the employee's risk of infection was outside of the workplace.
Okay.
Now, if the three things are the circumstances under which the workers' compensation presumption applies, there's three of those. One of which is as a practical matter moot.
All right. Well, thank you. We've got just a couple of minutes, so we want to thank everybody. For those questions that we were not able to answer, we will attempt to answer them via email. And I'm going to pass it off to Mr. Bill Cayley so that he can wrap it up for us. Thank you, everybody.
Well, thank you. Great job, guys. I just wanted to let you know that, we've got over twice the attendance that we've had at our other presentations. So I think you're doing a better and better job at presenting information and responding to questions. And I don't know about everybody else in attendance, but that was sure a lot better than spending 5 hours in front of Google looking for answers. And at the hourly rate that you both charge on a combined basis, I think we all got a huge value from the time investment. I've been working with businesses almost 30 years, and I can tell everybody, you probably already know this, that those businesses that have the have really well-informed policies, procedures, risk management policies in place, tend to perform and be a lot more profitable than their peer group. So it's the cheapest form of insurance you can get. I hate saying that because it takes revenue out of our pockets, but that's really how you make a more profitable business, have a happier crew, and have fewer insurance claims. As a reminder, we're going to have a brief survey after this. It's going to help us to help you better in the future. Carolyn, is that going to happen at the conclusion of this, or is that going to be
yeah,
during
if everybody could just stay on for a few minutes and complete 4 to 5 questions, that would be great.
Fantastic. Well, thank everybody for your attendance and for participating in the survey. And of course, please call Robert or Evelyn if you have any specific questions you need addressed, or if you want to engage with them independently. And of course, please give us a holler if we can help you on any of your insurance needs. Thanks again. Have a great day, everybody.